CPI report, Child Protection in Iowa, is brought to you by Vocal Victims of Child Abuse Laws. You can watch our program on Sunday afternoon at 1 o'clock. Again, we repeat it on Wednesday evening at 9:30, all on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com. We also appreciate phone calls from parents that need our help. We try to give the best information we can from our experience. We're not attorneys, but we're here to help parents. My number is 276-3956, and John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. You're right, we're not attorneys. We don't practice law. We do it right the first time. So we don't need the.
That's what the DHS is afraid of, isn't it?
That's correct. Sometimes knowing a little bit about the law is helpful, and if you're in a situation where you're caught by DHS or by the juvenile court, it's helpful to find somebody who has been in that position before and can give you a few clues and a few guidelines. That is not called practicing law or as they call it, UPI, unauthorized practice of law. That's just one friend helping another friend. And the Department of Human Services, of course, will want to try to scare you into thinking that you can't even share the papers that you get because those are so confidential. You needn't share those with a neighbor or a friend or with your parents because they might be able to give you a clue as to how to get beyond their accusations. If you do have a report against you or your family, these are called assessments. They point fingers at parents or caretakers of your children, and they are not the best things to have around. You should do everything you can to resist your child abuse reports, whether they're called investigations or assessments or whatever they're called. The most recent term that they've invented is assessments, because assessments sound less harsh than investigations. But what they are is that they're investigations. And they need to point fingers at somebody for abusing your child or your children. And they need that in order to garner some authority or some jurisdiction for doing things with your children that they couldn't otherwise accomplish. And in some cases, they'll go ahead with jurisdiction with your permission. They'll try to get you snagged into taking community care services, even though there is no reason to believe that your children have been harmed in any way. But they'll be using the statutes, and they'll be using the toll-free telephone lines and all of their mechanisms that are tax-supported in order to gather those names of families. They think they can reach out to at least 600 families each year and offer them services. It sounds like a marvelous thing. I would beware. Let's go back for just a moment and look at what it takes to resist a child abuse report. First of all, they have to tell you that they are, this is by statute, they're supposed to tell you that they are commencing a child abuse report, and I believe that's within 4 days of commencement of that report. So you'll get something called parental notification in the mail. that says, we're coming after you. We're initiating a report regarding an alleged child abuse report. They'll want to come to your home. They'll make a lot of people believe that they can walk right into your house and disrobe your children and do whatever they want. There is very little that they have authority to do. They can go up and down the street and talk to every one of your neighbors. They can go to your employer and talk to him. They can talk to your landlord. They can talk to anyone they want regarding the report. It wouldn't be wise, but it certainly wouldn't be fruitful to talk to all these people. But they can embarrass the living daylights out of you because they have the right to do that. The one thing is that they cannot enter your home, and that is a Fourth Amendment right. It's called the right of the threshold. They cannot cross your threshold. However, if they insist on beating your door down, it probably would be wise to say, if you cross my threshold, I'll consider it a violation of my Fourth Amendment right. But don't lock your door if you believe that they will smash your door down if it's locked. It's better to keep the door and to let them know that there's a Fourth Amendment violation underway. And then you can complain about the Fourth Amendment violation in a different venue. But in the meantime, there are a number of things that you should be doing. When that social worker comes to the door, and let's assume that it's a physical abuse report, and those mostly are in cases where parents have decided to spank their children. And in spanking their children, they may get a red mark. They may actually get a bruise. And if the children are not in imminent danger of their life and health, you certainly could bring the children to the door and say, no, you can't come in, but I'm going to show you my child. See, this child looks to be strong and healthy and has not been abused. That should allay some of the fears of the social worker and should set them at ease that the child is okay. However, there are social workers that don't stop there. They want to go further than that. And at that point, you say, well, I'm sorry, but you're not coming into my home. Well, what they can do then is to go to the child's school, where they do have a statutory right to have what they call confidential access to your child. And this is a fairly evil thing that they're doing now. They'll go to school and they can talk to other students and they can talk to your child and try to gather additional information about this spanking and other spankings that they've had. And some children are only too happy, if they're angry with their parents, they're only too happy to share all kinds of stories, jeopardizing the position of the parent. No child likes the idea of being spanked, and if you ask them about it, they're likely to tell you more than they know about spanking. One child told a social worker that he'd been spanked many times, and the social worker said, well, how did you know that you were being bruised? Well, he said, I could see the bruises. Well, 9-year-old boys are not built in such a fashion that they can check their tail feathers. And so if his tail feathers had bruises, he was doing some overreaching there as far as honesty was concerned if he said that he himself had investigated and found bruises. So sometimes children will tell more than they need to know. There is a case in Ankeny and this goes back a few years, Hildreth versus DHS, that really rocked the whole system because the judge ruled that there was no abuse, even though there was a bruise left on an 8-year-old child who had disobeyed her father, and she was spanked with a wooden spoon. Certainly didn't leave any lasting harm to the child, and it did a lot of good to the system because it said there's possibilities that you can continue spanking your child. It's legal in all 50 states of the United States to have corporal punishment. Some people don't believe in that. Well, that's beside the point. If parents choose to use this kind of spanking, they shouldn't be intimidated from raising their children as they ought to be raised or as they see fit. Well, let's take another look at this case. Don, you had a comment at that point.
Yeah, you were talking about the Hildreth case. Mary Wickman, the attorney for the represents the DHS for the state, she was the one that had that case, and she took that on appeal to the Supreme Court. As I remember, the district court must have ruled, and I forgot how they would have ruled, but anyway, she took it to the Supreme Court, and she lost. So that's an example that parents don't get discouraged if you have to take it to the Supreme Court level. Just your children are worth it. Keep fighting. John?
Okay, we want to point out when we're talking about expunging a report from the Department of Human Services, that is a completely different venue. That is a completely different court situation than what we think of in district court or divorce court or small claims court or traffic court. This is strictly an administrative, that is within the department itself, creates this report and puts it on the child abuse registry if there is a finding that somebody was at fault for abusing a child. And the abuse, the largest number of abuse cases are in the area of denial of critical care or lack of supervision, because those have the loosest definitions that invites the largest number of cases. Because if a social worker disagrees with your parenting, then you are behaving in a fashion which they consider to be poor for the child, and the child is therefore a victim of your poor parenting and your poor supervision. So everything is dumped into that category. And the largest number of cases, like I say, fall into that supervision, lack of care.
And I just wanted to give as an example a situation that I've actually encountered about 10 years ago or so, where I had my son's older daughter watch him. She's 11 years old at the time, I believe, and watched him. He was about 2.5, and she watched him for a period of about 30 minutes. Well, the nosy neighbors, and everybody has these, the nosy neighbors felt that was inappropriate. So what they did is they called the nosy DHS worker, and they basically, without doing any sort of thorough probing of my son's older sister's abilities to care briefly for her young brother, they came up with this notion of denial of critical care. Well, I'm sorry, but if the DHS worker that came out there would have done a thorough job, they would have found that the older sibling had watched other kids in the neighborhood and therefore had plenty of experience watching children. Well, they didn't even ask her that. They just assumed, based upon third-party accounts, what was going on. Well, and I took it through the processes, and they corrected the whole issue, and they threw out the finding of the DHS, which was good. But the process took well over a year, and it was just very difficult and frustrating dealing with the idiotic bureaucracy that a lot of us face in these sort of situations.
Yeah, but you give somebody, several people, a job. If you wouldn't have been there, they might have starved to death.
Well, my opinion is that it's better for them to starve to death than to go out there and mess up people's families with these sort of ludicrous things that they're doing, because it's not really a big deal if someone does that to you once. I mean, it might hurt you, it might hurt you personally, doesn't hurt you legally, but you get a couple of those against you, and watch out. They'll be coming after you saying that you're an unfit parent, and they'll try to terminate your rights or something. So it's really a scary time if you're a parent, even if you're a good parent. So you just got to watch out. Be wary of the DHS bureaucrats lurking, because they're out there. Trust me, and some of them are very weird.
Beware of the comment that we're here to help you too.
Yeah,
Yeah.
we're from the government. We're here to help. It's something like that adage about the letters in the mail.
Sure.
The checks in the mail. Okay, so
They're
we're
trained to say that, I think.
we're here from the government.
We're
Well,
here
let's
to
take
help you get your child rights
That's
taken
right.
away.
Okay, the first step is when you get that abuse report, and it's supposed to be ready for you in 21 days after the commencement of the report. Sometimes they stretch that out. They used to have to cough that thing up within, I believe, 10 days, and then they wanted more time, because it doesn't work out with their golfing schedules. If they have to get it done in 10 days, they might have to give up something. But now they have 21 days to complete that report. And what they'll do is they'll say it was dictated on the 21st day. And it might take them 4 days to get it to the typist. And it might take them 2 or 3 more days, to get it actually typed up. And it might take some time to get it in the mail. So you're well over a month before you actually get that report. But you can hound them for that report, because once you get the
but
the
you
notice-
don't automatically get the report, John. You got to ask for it.
That's right. So you request the expungement.
Even though they're supposed to send it to you, which
Yeah.
they didn't in my case. They didn't ask for my participation in the actual investigation.
No.
They just sent me the conclusion.
Right.
But they're
And-
glad for your business, though.
And I corrected them on that.
But
You
you
know, when we
actually
got to the-
but you actually have to go to the department, not in person necessarily, but you have to contact the department, and then you have to sign a form of SS-1606, because that's they're letting something out of their office, so they have to have an SS-1606, which shows that they can disclose that information to you, because you're the parent of the child. Or in some cases where the perpetrator is not the parent, the perpetrator gets a copy of part of the report, because now they have all kinds of parts of the report. Some of them you cannot get a hold of. But in any case, you once you've read that report, the report is built like this. First of all, it's fact-finding. In other words, they're supposed to go out and pick up all the relevant facts from all the credible witnesses that they have, and put those facts down on paper. Then, based upon the facts that they know and the manuals that they have that give them some guidance, then they're supposed to be able to come up with conclusions. Well, if the conclusions are not supported by the facts that they have, then you have a faulty conclusion, and you can challenge them on their faulty conclusions. And sometimes they just put these together with a little less intelligence than a third grader, and that isn't to demean.
Hey, that's insulting to third graders.
I was going to say that isn't intended to be demeaning to third graders, but you would think that when you pay these people $55,000, you would expect a little more intellectual rigor to the task. Then you request a review of the proposed ruling. Oh, I'm sorry, we left out a step there. you request the evidentiary hearing, and it is in this evidentiary hearing, and that may be a new term to you, but what it is, it's a fact-finding hearing in which all the parties, you can call all of the witnesses to this case, and you can cross-examine them, and you can do something called discovery. And we're going to turn to Don to talk a little bit about discovery. What is discovery? How much is too much? And can you ever have too much discovery when you're fighting the Department of Human Services and discovery? What things should you be careful of when you are going in the routine of discovery? How careful do you have to be sure that you're doing it in accordance with the way the courts like for you to do it outside of the court sessions? Okay, Don?
That's too many questions for me, John.
Okay, shoot.
Yeah. I wanted to make a comment on you were saying you need to ask for an evidentiary hearing. A lot of times we'll call that an ALJ hearing because that stands for the administrative law judge that hears the case. So administrative and ALJ is kind of interchangeable. You were asking about the discovery. Discovery means that you can go after information. You have a right to go after discovery because you have a case, whether it's an administrative arena that John's talking about or in district court on a lawsuit or something. That once you start that action, you have a right to get discovery. And there's a lot of different kinds of discovery, really. One of them is through the subpoena route. Well, most people think of the subpoena as a demand for witnesses to come to court. Well, that's one of them. And as a result of them coming to court, then you can ask them questions, which leads to discovery, more information. Another discovery technique that DHS has to honor, believe it or not, they're supposed to follow the law, but they try to skirt around it, is the open records request, and that's very simple. And if you need some more advice on that, give us a call. It's a request for the whatever information you'd like to have. Now that is similar to the subpoena ducus tecum that I mentioned the subpoena before, but you add ducus tecum to the subpoena. You put a check mark on the subpoena or make that request to the ALJ in this case, and they fill out the subpoena. And you're requesting information to a certain person. You put the name of the person down, and then you or somebody else can deliver that subpoena to another person, to the DHS agency, to the...
I had a question.
Go ahead.
I think a lot of people out there would probably know what you mean by ducis tecum, because, I mean, that's some Latin stuff that they just throw out there that confuses, so I thought you might want to clear that up. So
attorneys know all about it.
Yeah, well, I mean, but the average person out there watching
That's true.
is probably not going to know, and that pertains to documents. When you have a subpoena that's designated ducis tecum, or however heck you pronounce that terminology, that deals with documents. You're looking for documents pertaining to something, and you have to spell out what they're related to, so they're relevant. And I think I'll let you finish the rest there. I don't want to get off into a long explanation on that.
One advantage of the subpoena ducus tecum, if they refuse, and especially DHS is well noted for that, for refusal, you do have the opportunity to go back in front of the judge or the administrative judge, ALJ in this case, and have a hearing on the subject to let him decide whether you have a right to records. And the DHS will squirm around and try to get out of it no matter what. And a lot of times the ALJ will go along with the DHS. But that doesn't mean it's always that way, because by law you have a right to your records or any other kind of information that pertains to your case personally, not to somebody else's case, John Doe down the street, you don't have a right to them because this is confidential information, but you do have a right to your information. And
Can you have too much discovery?
oh, well, attorneys believe so. I had an attorney years ago that I said, I want a little bit of discovery here. Oh, no, he said, I got too much right now. I'll never get read through what DHS gave him to read. He wasn't interested in going after the facts of the case and doctor's statements. Oh, that would be too much work. No. Well, anyway, that's a way attorneys work. But for a parent, if you want to win that case, you better go after your records. And there's a lot of different kinds of records. You got your abuse report that John mentioned earlier. That's the very start of the case. And then once they get your children into the DHS, they're in foster care. So now they are generating a foster care file. Well, of course, they don't want you to see the foster care file either. In the DHS files and foster care files, you can go after a narrative. Now, if you don't want to cry, if parents, there's especially the mothers out there that get emotional, well, you don't want to see that narrative because DHS workers put a little more truth in there, and they'll describe, it's like a diary, they'll describe your child's aches and pains and how they cry and how things are going on. But that's a key part of your case. If you want to get your kids back, I encourage you to go after that narrative. Attorneys don't care. They're not after winning the case for you. But if you want your kids back, you better start fighting. And this is just like war. When if Hitler would have started bombing the United States, would you just say, "Oh, that's all right. We'll turn the other cheek," and just let them destroy you? Well, Jesus said, "Turn the other cheek." I believe it was Jesus, but he also talks a lot in the Bible how we need to resist this wickedness that is going on. And in my opinion, DHS is an abomination to God. God created families, and DHS is coming along and thinking they know better how to handle the children, and so they're going to destroy you if at all possible. So fight back. John?
Okay, one question that you didn't cover, but I'll make mention of it here, and that is, it's up to you to do an informal request for the discovery information that you want. You don't run to the ALJ to enforce something until you have made a good faith effort on your own to talk to probably the worst people in the world, and that's DHS workers, and beg them for information from your file.
Are they a rattlesnake in the grass, John?
Yeah. Oh, well. You have they may not be the friendliest people. They may not be the most cooperative individuals, but the ALJ and the subsequent courts will expect you to exercise a good faith effort in getting that stuff on your own, and it's better to do that all in writing so that you can prove that you have made a good faith effort in describing the stuff that you want and in following through and getting the information that you need. Then when it comes time for enforcement, then you can show the ALJ that on several different occasions you made both verbal and written requests for the information, and that you were told by certain individuals that you couldn't have the information, or that they simply ignored you completely. For one reason or another, you can report that to the officer who is in a position to enforce your request. Now, the ALJ may not agree that you have a right to that information. They may not agree that even if you have a right to the information, that it would be productive. So you may have an argument with the ALJ at that point, and you may have to prove that the information that you're requesting is valid information. Any information from your pediatrician should be yours. Any information from the school should be yours. Any information from the daycare center should be yours. And the reason why you want it shouldn't be up to the ALJ, and how you present that information should be entirely up to you. So those are some ideas about discovery, and I wanted to touch on that particular topic here on today's program, because I think that the more we can do to resist these reports, the less likely they are to keep on expanding the whole thing. I know when we first started this, Don, there were fewer than 100 reports resisted per year, and now it's up into the hundreds of reports that are being resisted. And they may not all come from this program, but I think this program has had a significant influence in increasing the number of resistances to the child abuse reports on the registry. I think they should actually shut down the registry. It has no useful purpose. They're using it now almost like an employment referral system. In other words, using it to check to see if people are on the child abuse registry in order to know whether you should be hired as a nurse or you should be hired in some other capacity in which there's children available, even restaurant workers, because there are children that sometimes go into restaurants. And so they might want to check to see if you're on the registry. So they're using the registry almost like a personnel checking device. Okay, any other? Okay, can you put that up there, back up there for just a second? We'll take a look at a couple of other things here before we move into how you actually make your mark, making your request for expungement of and getting your evidentiary hearing. Two other steps that the ALJ, after he looks at your case, he or she looks at your case and goes through 2 or 3 days of hearings. By the way, you get to cross-examine everyone who has information bearing on your case, and you get to call all the witnesses that you wish to call, and you can introduce whatever evidence you wish, and you can discuss every issue regarding this matter. We have a case called Mock versus DHS, which went to the Iowa Supreme Court and proved that there are no issues which the department can ignore in this business of the evidentiary hearing. So he did the public a real favor in arguing his own case. He had no attorney. He just had a heart for his family, and decided that he would take on the Department of Human Services. In this case, he took them on, and he won.
Takes persistence, though.
Yeah. So they'll come out of that ALJ hearing, which is a fact-finding hearing, something called a proposed decision. And that proposed decision becomes final when it goes to the director of Department of Human Services. And apparently now they like to make you believe that you have to appeal to the director of Human Services to make, and that director then within 10 days will make that finding a final agency decision. Once it becomes a final agency decision, you have left the administrative arena. There's no more venue dealing with the administrative arena now, because now you're going to the courthouse, and you'll be filing a petition for judicial review under Chapter 17A of the Iowa Code. And that's fairly simple reading, and it gives you a good idea of how those cases are handled. You probably want to contact somebody who's been through that process before you tackle it yourself, because you'll want to frame your issues in such a way that the court can easily understand what kind of a problem you have with the Department of Human Services. And that's also where you can make your complaints that the ALJ did not enforce the discovery request that you made. If you don't get from that decision for judicial review the things that you wanted, the relief that you seek, then you can file an appeal with the Iowa Supreme Court. Here again, you might want to talk to somebody who's done that before or is familiar with that process. And it doesn't hurt, if you've got a good attorney and you've already got your papers put together and you want to give that attorney a few dollars to look over the form of your report. Sometimes an attorney can do for $100 what would cost $10,000 if you signed him up to do the whole thing for you. So
I was about to say, where do you find one of those for a few dollars?
I've done it before. I've done it before.
A few dollars?
Sure.
And you won the case?
And
Wow.
so
We need to know that attorney's name.
okay. It's one way of skirting this whole thing of hiring an attorney, because when you hire an attorney, they can spend $5,000 before the first coffee break. So you want to be careful with that. But you can hire them by the hour. And if they don't want to do it, that's fine. You just go to another one. They're trained to do that, and they should be able to help you out. Okay.
If you wave a little money in front of them, maybe
Right.
they'd answer
Sure.
a question.
Sure. And they're skilled at it. They should be able to accomplish that.
Now,
Don?
we give free advice here.
Don, yeah, and it may be worth that much, but
Just not relating to any specific cases.
right, right. Okay, now, Don, show us what it looks like, what kind of information we should have to get this whole thing started. Okay, you got something there that will help.
Well, first, or secondly, I'll show the information you were referring to. But this is to get an appeal rolling, or not an appeal, an evidentiary hearing that we were first talking about. You contact, you want to bring that up, John?
Thank you.
You contact Rhoda Harris, and there's her phone number. But you can do this all on the internet to get the ball rolling, so to speak. Yeah, here's a short version. This is all you need to copy down to bring it up. Type this into your internet and bring it up. And then I will switch to this here. And
Okay.
this is what you...
That's what the screen looks like, is it?
Yep, that's what will pop up on the screen, and you see up at the top here again is that same website. Anyway, it's a fairly simple form. Your name and address, phone number, and you fill in the box or whatever to apply to the case.
This would be
Yeah,
child abuse over
food
here.
stamp issues, or what'd you call it, John?
I think a child abuse report.
That's close enough.
Uh-huh.
During the appeal process, do you want your benefits to continue?
You don't have any
they're not going
benefits.
to give you your children back until you beat them in court. Do you want the department to provide an interpreter? Well, we got a few people probably out there that's listening to our program that's struggling to understand, or maybe a friend will pass this information on. And so they have an obligation to provide an attorney by law, or a interpreter. And briefly make your statement. Don't take too much time on that.
Can I send this in by computer too then?
Down at the bottom, it'll after you've filled it out, you hit the send button. I'm not sure what the word actually is. Probably send, and it goes to, who does it go to? Let's switch back here. To Rhoda Harris.
Well, we can do this in writing, or we can do it on the internet, right?
Well, you can, if you want to, you can even copy the form and fill it out and hand deliver it in person. she's pretty good at responding back. If you don't hear a response in a few days, I'd follow through by telephone or in person and make sure she's got it. But I'm guessing you'll get a response right away. And what you're actually after is a case number that goes into the evidentiary hearing. And until you get that, you have nothing as far as this request is concerned. So that's what you're pushing for. And once you get that there, then you leave Rhoda behind, supposedly. She may fight against you as not an attorney, but she'll represent DHS. In a lot of cases, she must anyway. And so you basically leave her behind as far as, isn't that a conflict of interest?
I'm not sure.
Where she can assign the cases and then turn around and fight against you?
Yeah.
I don't know, but anyway,
That's interesting.
then you go into the evidentiary level, which is over at the Lucas building, and then a file is being generated at that time. John?
Okay. We didn't introduce Terrance Walker earlier, but for
Just
for
leave me
most
out. Leave
for,
me out,
for,
don't
for,
you?
for most for most of our viewers, you've already been introduced to him several times. He's our courthouse consultant, and he looks into some of these issues as they pertain to the inner workings of our marvelous judicial system. So if you'd like to know something about the judicial system, let's turn now to Terrance Walker.
Well, thanks again, John. Well, you just wait till the end of the show to introduce me, don't you? But
The best to last.
hey, that's a good thing. Yeah, I'm the judicial correspondent slash chief judge, and I will say self-proclaimed chief judge here because no official title or anything like that. But I do think that if some of the officials that we have representing us here in the state of Iowa, especially in the courthouses, can call themselves judges and chief judges, then I feel that I'm of sufficient moral character and legal knowledge to call myself a chief judge. So there you have it. I did want to comment on a couple different things here. There's a really I guess I should say, amazing article out of the Des Moines Register. I guess it shouldn't be this amazing since I've displayed a number of these here lately. If you could show that for the people there, Don, and we could actually get the executive producer, to flip the switch so we can check this out. It's called the Capitol Bullies. This was actually put on the.
There we go.
This was actually put in the paper on April 5th, 2005, titled "The Capitol Bullies." Register editorial board. Friends of the court, obviously. If a bunch of street thugs try to intimidate judges, it's criminal conduct of the worst sort because it undermines the rule of law. If a bunch of congressmen try to intimidate judges, well, that's just politics as practiced by Iowa's own Steve King and cohort Tom DeLay of Texas. After the death of Terry Schiavo, King and DeLay issued veiled threats of retaliation against federal judges who didn't rule the way that congressmen wanted them to. I will not allow a federal judge to ignore federal law without consequence, huffed King in a statement. We must rein in the runaway judiciary and hold judges to their oath to uphold the Constitution and the laws of the United States. If a judge refuses to follow the law, he is no longer just and impartial and must be removed from office. The time will come for the man responsible for this to answer for their behavior, House Majority Leader DeLay threatened ominously. The King-DeLay judge-bashing tantrums represent politics at its most odious. The pair were among Congress's most ardent advocates of interfering in the Schiavo tragedy. Their outbursts followed the federal court's repeated refusal to overrule Florida state courts in the Schiavo case. Never mind that the federal courts were right and Congress was wrong. The federal government had no business interfering. End-of-life decisions properly belong with the family and doctors. Where there is disagreement among family members, the state courts come into play, as they did in the Schiavo case. If King and DeLay truly believe the judges violated the Constitution, let them introduce articles of impeachment against every judge involved. Let them lay out specific charges against a federal judge, the entire Atlantic Circuit Court of Appeals, and every member of the U.S. Supreme Court. Then let the public see that during the impeachment hearings just who's respecting the Constitution and who isn't. Here's betting that King and DeLay isn't. Well, I just had to say a few things about this rather eloquent but ignorant editorial. First off, the comment that never mind that the federal courts were right and Congress is wrong. This article does not in any fashion prove this statement. There is no proof. I've read the opinions. I don't think that the editorial board has read the opinions of the courts in this case. Never mind, I won't get into whether it was right for them to interfere in this matter or not. My whole thing is the judiciary, and this is my subject that I deal with week after week. Here we have a case, in the Schiavo case, where Congress done its rightfully and entitled duty to make laws. They made a law, and they said that they were supposed to hear this case anew and not bring up all of these hurdles that they impose upon people when they go to federal court. And I guess Congress is well aware of these hurdles because they wrote this law specifically designed to do away with these hurdles for Terry Schiavo's case. The judges who enacted these hurdles, which are basically judge-made doctrines and judge-made law that says that they're not supposed to hear a case once it's been heard. They're not supposed to hear a case that might conflict with a state opinion of a court. Well, all that's fine and dandy, but that is not because the judge previously made opinion of that in the past. That is not to say that this is the way Congress intended this law to be interpreted. But they feel obviously in the last opinion that I read of the 11th Circuit Court of Appeals in the Schiavo case, which was the last court to actually issue any sort of written opinions. There was like a number of split opinions in the case, but the main one that really rung out in my head, which kind of I think underlined the whole opinion of all the courts when they were dealing with this matter, was the one that said that this is violating separation of powers here, when in fact there was no separation of powers involved. The judges did not want to hear this case anew, so what they did is they invoked all these doctrines that said that we're not going to hear this case because it's been heard in the state courts. Rookman-Feldman doctrine. They brought up the fact that they're not supposed to hear a case all anew, which has been heard before. They brought that doctrine up. Well, these things are not constitutional precedents. These things that they brought up were stuff that was all made up by judges. And Congress has every right and power to bring up a new law that says the standards and of which judges are supposed to hear cases. And they were right in this matter. So I think that the Register Editorial Board needs to do its fact-finding and logical deduction before they come to some sort of conclusion like the federal courts were right and Congress is wrong. You cannot come to that conclusion without proving it. You have to do some legwork and some logic here before you can just come up with a conclusion and print it in the paper. You're not doing adequate journalism, Register Editorial Board. I just wanted to put my 2 cents on that, and I will be putting my 2 cents in next week's Register myself in the letter to the editor as well. Did you have some comment on this, Don and John?
Go ahead, Don.
No, I didn't volunteer anything.
Okay. No.
John, speak up, John.
There were a few things. I think we have to commend a society that looks to the husband, all other things being equal, of having the premier decision making in a case like this. However, in order for him to qualify as a husband, one would think that he would have to be faithful, because that's part of being a husband. Secondly, he would have to qualify by having the appropriate documents. The appropriate documents would have been a living will. That did not happen. That was a figment of his imagination, and it should have been seen as a figment of his imagination, since he was not able to produce that document. To take hearsay information, as these judges did, is totally inappropriate. And I think we should think of our judges in far finer terms than these judges who are willing to take garbage in place of competent evidence.
Well, what do you have to say about the fact that the congressmen are saying that the judges ignored federal law? In ignoring their law that they made specifically to allow this case to be heard anew. What do you think about that?
To me, when they say we want the case to be heard anew, you start from scratch. And you look at all of the evidence, even though the evidence may be preserved in the record. You look at all of it brand new, as if it was the first time that it had come before any finder of fact, and the courts refused to do that. And I think you made a good case there when you said that they decided they didn't want to do that.
Exactly.
To me, they should be held in contempt of Congress.
Exactly.
Because when Congress speaks, that means something. And when we have separation of powers, that means that when the legislature is in session, when they speak, we'll have to listen to them, don't we? They're the representatives of the people, and most of their membership is accountable every 2 years. The accountability of the judges is zip.
Exactly, and I think there was a good article that I wanted to talk about here, but I don't really have the time to. It was a letter written by attorney Gary Zerman to the president of the ABA, which was basically responding to a letter by the president of the ABA that a comment that judges deserve our respect, not our scorn. And this was the theme of his speech he made a couple weeks ago. And I think attorney Gary Zerman made a good case, and you can actually go look at a sample of what his argument is on constitution.org about how the judiciary in this country has made itself not accountable by interpreting in its own doctrines the right to have judicial immunity from lawsuit. I mean, judges can do almost anything to a citizen, short of actual crime like going out and shooting somebody. But if they're doing it in the courtroom, hey, you're not going to get any redress in the courts. You're going in front of another judge, and they're going to say they have judicial immunity. They're not accountable. And another point I wanted to make about this article, and I'll leave this alone because I think we played a little bit out of this last week. I think that the Register editorial board was basically drawn upon the conclusion that the judges were right because there were so many judges that ruled a certain way. That does not mean that the judges were right because there are so many judges that ruled a certain way. We cannot just assume because the courts ruled one way that and they all ruled in a certain way that they're right. Common sense would dictate that if you look at what's going on here and look at the actual opinion, there was one lone dissenting opinion which I think that everyone out there should read in the Scheibel appeal in the 11th Circuit Court of Appeals. You can go to the 11th Circuit Court Appeals opinion page on their website and actually look up this opinion. But the one lone dissenting judge he hit the nail on the head in saying that the main judge deciding the case was not using anything that was backed by any authority, any law, any previous case when he said that this was a separation of power issue, that Congress had no right to tell them to not use all these doctrines and decide in this case. They're not supposed to. Congress formed the judiciary. Why can't it dictate how the judiciary operates? It doesn't make any sense that this separation of power. Who's to say that they have that is a separation of power issue? There was no authority to say this was a separation of power issue.
They brought them into the world?
He brought this out of the woodworks to say, well, this is a separation of power issue. Well, I'm sorry, it's not a separation of power issue because you haven't shown that conflicts with anything that has been laid forth in the Constitution of the United States that says that Congress cannot do this. They did it, and they have a right to do it if it doesn't say that they can't do it in the Constitution. So,
well, Congress brought those courts into the world, and they can take them out.
Exactly, and let's hope that they do, and I hope that they clear them up.
You bet.
One other comment I'd like to make.
Sure.
I think I wanted to relay this. This is from Iowa court here. I just wanted to get that quote there. This is Chief Justice, or not, Judge Rue here, Judge Dale Rue in Iowa courts, Iowa District Court. Look at this quote here. This is a criminal case, and he's telling the defendant, "Oh, I remember the argument you raised, and I will very candidly admit to you, there is an argument here that what the word falsify in the statute means. And I will candidly admit that there is an argument there, and that falsifying means altering a document to make it false. And I understand evidence doesn't show that here, but there is another definition of falsify that might apply to this case. There's no decision of our appellate courts that gives the court much guidance in this regard. So I candidly admit that you've got an argument here, and I understand what you mean, or you're saying, and you may ultimately be right. I'm not sure." This is the way the courts act, and this is a prime example here in the Iowa court. Judge Dale Rue, R-U-I-G-H. If you want the screw, go to Judge Rue.
So he ruled on something he wasn't sure, but he threw out the facts?
Yeah. In other words, he's guessing in a criminal matter. A felony at that matter. I mean, why would you guess in a felony? But, this case is actually being decided, case number 03-1173, Iowa Supreme Court. Let's see if they get it right this time.
Okay. Hey, thank you for those reports, and we're running short of time here, but I wanted to let you know that the state legislature is working very hard on child abuse reports. They like to operate under crisis, and so when a little girl is killed, they want to make more and more laws, and one of them that they're going to examine to see if it was a valid law in the first place is the Sexual Offenders Registry. Doesn't really work, but it's costing us $1 million. So here are a couple of numbers that you may be interested in contacting. We'll see you.